147 Moselle Road. I need the police to answer immediately. My wife and child have been shot badly.
This is your wife and son?
Did I kill my wife? Yes. No, David.
It's just so bad. They did it so bad.
There's not one shred of evidence.
One question begets another, which begets another.
I go by Buster.
Do you have any idea who's done this?
Good morning from Colleton County and your Walterboro crew as we continue our live team coverage of the Murdaugh murders trial. I'm Judy Gatson along with Greg Adeline and Nick Neville leading our live team coverage for day 28 of this trial. And Greg and Nick, the big question at the beginning of this trial every single day is checking in with the jury. We know that we had 6 alternates at the beginning of this trial. A number of alternates have been moved into action, so to speak, because jurors have been sick and for other reasons. And so we are waiting this morning just to get that check to make sure that the jury's okay. But we want to show you where we are right now with the jury makeup. And then Greg is going to start with a recap of kind of what the highlights were yesterday. And Nick will talk about that trip out to Moselle yesterday as well and the impact it could have on this trial. But the jury breakdown as we know it to be right now. I know it's been kind of hard to keep up with all of the twists and turns in this trial, but 2 black jurors, 10 white jurors, 6 men, 6 women, and 2 alternates, a male and a female. Again, that's what we know the jury breakdown to be right now. They are supposed to start at about 9:30. We'll be with you until they get going in the courtroom. But Greg, as we look at that makeup of the jury, our trial analyst, Carl B. Grant, made an excellent observation yesterday. 6 women sitting on that jury, and I heard some feedback, I would say, from people who were inside of the courtroom. When Creighton Waters talked about Maggie running to her baby, they saw a visible emotional response from some of those women on that jury.
Judy, that was one of the key moments of the day in Creighton Waters' closing argument when he was talking and appealing to those jurors very likely and coming up with a memorable line in a closing argument to really appeal to emotion, saying Maggie Murdaugh was running to her baby, as you said, because after all, throughout all of this, most of his, at least his questioning has been very clinical. It's been laid out in a very clinical way, very matter of fact, sometimes tedious, and many people who are watching this trial, including Nick and myself as we're watching it, thinking there has to be a point in time when he connects with that jury and makes a compelling case by way of at least appealing to emotion. And when he did that, that was certainly part of it. He was able to humanize Maggie Murdaugh and Paul Murdaugh in ways that perhaps even some of the witnesses in this case haven't been able to do so far. That was a big part of his closing argument, but really he spent a good part of the morning going through many of the motive arguments that the prosecution has tried to establish in this case, essentially saying that there was only one person with the motive, with the means, with the opportunity to kill Maggie and Paul Murdaugh, and that would be Alec Murdaugh. They really tried to hem him in. They did that by way of the timeline, of course, and also talking about that kennel video, highlighting time and time again Alec Murdaugh's credibility and just dinging it as they could with that kennel video when Alec Murdaugh finally from the stand admitting that indeed he was at the kennels at that time. Now, also, Alec Murdaugh just moments ago appeared here today at court. He was brought in, as he is every day. We've seen this for the past 27 days. But today, they brought him out of the van, and he kind of stood there for a good 30 seconds, which was a little bit different. We hadn't seen that in days prior. Then made that walk into the courthouse. Only a few questions were shouted to him. But again, you really can't overstate this. This could be the day that he finds out his fate in this trial. It's been a long-lasting trial, obviously, 5.5 weeks and counting. And so today, after the defense makes their closing argument, it'll be in the jury's hands. The jury will be charged likely later this afternoon, and then, of course, the jury will go into deliberations. There's questions right now as to whether or not they'll be sequestered during that time, but Judge Newman has made it clear that the jury will stay through the weekend.
Yes,
if
necessary.
So that is, I think, something that may play on these jurors. Another piece of reporting that we're working to confirm is that there may be a juror who is dismissed. We may hear that this morning from the bench. Judge Newman will likely say that as soon as we open up here. He's done that in the past, Nick. You've seen this where Judge Newman will give kind of an update, especially on jurors if they've been dismissed.
Right.
This morning we may hear about the status of a juror. We don't know who it is necessarily that may be dismissed.
And you know what, Nick, we're going to hear from the defense today. We should point out to our viewers, Jim Griffin is going to be the one. I think a lot of people anticipated it might be Dick Harpootlian. Creighton Waters yesterday, as Greg pointed out, with that Snapchat video. Can you just imagine, you guys? Paul's battery was at 2%.
Yeah.
With that at 2%. Without that Snapchat video, I don't know what case the prosecution would have been able to make.
And
but
that's the one piece of evidence that Murdaugh didn't know was there.
Was there, exactly.
And I think a lot of people were, anticipating that we would hear from Dick Harpootlian in closing arguments, because he of course made the opening statement, and he said there's not one shred of evidence. He talked about how everything that you heard from the state, everything that you heard from Creighton Waters is just a theory because you can't prove it. He even at one point during his opening statement, Dick Harpootlian stipulated that you will hear Murdaugh's voice with his family, but it's a pleasant family conversation, alluding to the fact in that kennel video that they're all there. One thing that it is, important to note as we talk about these jurors, and we've talked about it many times, there was a bit of a concern surrounding COVID, and so, that was an update, as you mentioned, Greg. Sometimes we'll hear from Judge Newman at the start of these days. There was that one day where he mentioned that 2 jurors had tested positive, and they had to be dismissed, and there was a question as to whether or not that could further delay this trial, that could essentially cause a mistrial. And speaking of those jurors, they did have the opportunity to go to the scene of the crime yesterday, and that's something that's going to be very significant. The defense wanted them to do that to sort of get a better idea of some of the spatial awareness of where the feed room is located in relationship to where Maggie's body was found. Also important, they felt, for jurors to understand the distance between where the kennels are and where the main house is located. So they went there yesterday. Judge Newman went along with them. Dick Harpootlian was there. We were told that Jim Griffin was not there as he was preparing for his closing argument. Jurors were not allowed to sort of ask any questions. It was not necessarily a guided tour, a guided field trip, or by any means, but it was an opportunity for them to, after they've heard for 5.5 weeks of testimony here about the family estate, that 1,700-acre property at Moselle, an opportunity for them to get an up close and personal look at that, to sort of have a better clearer understanding as they start these deliberations, which could happen at any point today. Again, it's unclear definitively if they would deliberate over the weekend. That's something that could happen.
Right.
Judge Newman may allow that, but it's also uncertain. We also need to note that you are going to hear from Jim Griffin here very shortly, but then we're expecting that John Metters is going to give a rebuttal for the state. So the state will have the last word before the jury is charged.
And you know what, about that Moselle trip, Greg, there are a couple of observations that we're able to share with our viewers. Number one, as Nick mentioned, they couldn't do any demonstrations or presentations out there, but we learned from the pool crew that went there that after touring that kennel area, they made another stop kind of in a wooded area over there. No information at this point about what that was about or why they made it. We also heard some observation, Judge Newman rode out in a pickup truck. They're typically used to seeing him in the robe and all of that, but he was in casual attire yesterday. But Greg, I wonder, as we looked at that video yesterday, I wonder if it might have had a different impact with the jury if they had been able to make that trip before they heard all of this testimony about the different theories, to really be able to have a picture in their mind of whether those theories were plausible. Because now to see it after the fact and try and go and apply everything that you've heard, and they'll be able to go back and look at the video and do all of that. But it's just one of those things you wonder about the timing of it and if it could ultimately have an impact.
Yeah, the timing of it, very key. You wonder whose side that really plays to, whether it's the prosecution or the defense. But in talking about that tree line, that is an important facet. What were they looking for out there? Were they trying to see how far, as Nick mentioned, the house is from the kennels, wondering how much that area had possibly grown up in the past year and a half? Seeing if it maybe now acts as a sound buffer, because after all, you remember Alec Murdaugh said that he didn't hear any shots fired at the kennels while he was at his house. He arrived back at his house at close to 8:49, 8:50, right around the time that prosecutors say the murders happened at Moselle, and he said he didn't hear any gunshots. So that's definitely a key point there.
Absolutely.
But when you talk about Jim Griffin giving this closing argument today, Dick Harpootlian is not giving it. And Judy, you had some reporting yesterday suggesting that Alec Murdaugh himself...
That it was his decision, that he wanted Jim Griffin to give this closing argument. Now, I can't read into any insight into why he would have wanted that, but it comes from a very reliable source. And we know in this trial that the decision for Alec Murdaugh to testify
was exclusively his own.
Yes, his attorneys tried to talk him out of it, and our trial expert says he probably should have listened to his attorneys. But I'm told that this was indeed Alec Murdaugh's decision to have Jim Griffin deliver these closing arguments instead of Dick Harpootlian. And it made me think back, Nick. Remember in the opening statements where Dick Harpootlian told this jury, "It's my honor to represent Alec Murdaugh." And so now for this jury to know that Alec Murdaugh is a liar, to know that he lied to them about the blue lights being installed in the car, you know,
just
to say,
last week.
Yeah, just last week. So I'm just wondering if any of that may have played into the decision of, listen, if it's your honor to represent a man who has demonstrably been just a liar over and over and over again, I don't know what kind of relationship they might think that Harpootlian has with the jury, and if he thinks for some reason that Jim Griffin will be able to make a more persuasive argument.
Right, and he did stipulate, Murdaugh stipulated that he lied to his family, he lied to his law partners, he lied to pretty much everyone close to him in his life about stealing money, about his drug addiction, and also about that key fact, that key element in this case, which is the video taken by Paul at the kennels. He told, including his brother, John Marvin, that he was never there. Right. And then we later learned that John Marvin was told by SLED in August of 2022 that Murdaugh's voice was there, and they did place him at the scene of the crime just moments before the shooting happened. And one thing about that, too, as you were talking, Greg, about Murdaugh being back at the home around 8:50, one element of the story that he told jurors last week is that he had the TV on, and so his argument is that he didn't hear any gunshots because he was laying down. He, had the TV on, and Creighton Waters touched on that yesterday and basically called it, I believe, the quickest nap in the history of the South, because he would have had to lay down for only about a few minutes.
Let me make a quick observation. Every morning there's been a long line outside of this courthouse. They have now let them in for the people who will be able to have a seat inside today. So we are definitely keeping an eye on the courtroom proceedings to make sure that we bring those closing arguments to you the moment that they start happening. That we don't want you to miss a moment of that. But Greg, the question today is, what does Jim Griffin have to work with? What is he going to do to try and convince this jury that Alec Murdaugh, yes, he is a professional liar, but he's not a murderer? Because they have, the prosecution and the lead prosecutor, Creighton Waters, drilled down this timeline so tight. I don't even know what other alternative theory they can offer that the jury will find plausible.
Well, I think one of the things that you're going to see is what you've seen a lot in the cross-examination of many of these witnesses, including, just the whole idea that Alec Murdaugh is a man of, they would say, is a family man, somebody who loved his wife, somebody who loved his son. They've tried to highlight that through different pictures and through different scenarios in which the family appeared happy in different ways. They will also, watch out for this, they will also very likely describe just how brutal and grisly the crime scene was.
Yes.
To juxtapose that to Alec Murdaugh sitting there.
How could
how could a man possibly do something like this?
We are hearing that Judge Newman has walked into the courtroom. Again, we are waiting, first of all, to get the update on that jury, because, Greg, that will be key today. They have talked about how long this trial has gone, and we know for a fact it's gone longer than the defense expected, because the resort-like facility that they rented to come down here and work out of in Walterboro, they had to move out over the weekend because it was already rented out for another venue. So they clearly expected this to be done before this point, certainly within about a 3-week time frame. So what we know about that, Greg, is that we're going to the courtroom now. We understand that Judge Newman is ready to get started. We'll have your live coverage throughout the day on WIS News 10.
Indicated and provided a copy of the communications to the defense counsel. After court, we then met with the juror on the record, and the juror denied discussing the case with anyone not on the jury or with anyone on the jury. She provided information that led us to the court to contact the persons that she was suspected of having conversations with concerning the case. Those individuals were interviewed and provided an affidavit regarding the contact that the juror had with them. We then also brought those two individuals in and had a hearing in chambers on the record in the presence of counsel yesterday. In which both of those individuals waffled on the nature and the extent of the contact. They also provided a recorded interview, or the state provided a recorded interview with the jurors, and I reviewed that interview last night. So the juror has had contact or discussions concerning the case with at least 3 individuals. Though it does not appear that the conversations were that extensive, it did involve the juror offering her opinion regarding evidence received up to that point in the trial that the conversation took place. And in order to preserve the integrity of the process and the interests of both the state and the defense in a fair trial, that juror will be removed and replaced by another juror. I will make a part of the record under seal because of maintaining the confidentiality of the identity of the jurors. I will place under seal the recorded interview, affidavits received, and both discussions with counsel have taken place on the record, and all of that will be made a part of the record in the case. And we'll bring the juror out to inform her that her services will no longer be needed. We will then replace her with an alternate juror. Any additional comments by the state or the defense?
Not from the state,
Your Honor, we do not accept from your ruling.
Yes,
I've sat through everything you sat through, and it's muddled, but we would defer to your judgment. However, I think it's important for me to note for the record that the interviews of these 2 people were done by SLED agents, one of whom was named as a witness in this case, and the other who was listed in the notes as being one of the investigating officers. Just to note that, again, SLED has made another bad judgment in this case. I'm not accepting from your ruling.
Yes.
I'm just pointing out that this is just a continuum of a calamity of errors. Thank you.
And the court has not had any discussion with any SLED agents concerning this issue. And all the inquiry by the court has been directly with the suspected parties involved and with the juror. And this is a matter that this long trial with the intense publicity is certainly it would be certainly difficult for any individual to not have some exposure outside of the courtroom to information concerning the case, and to also be tempted to engage in discussions with others. But it is improper, it is contrary to my instructions to the jury daily, multiple times per day, and this juror unfortunately violated that order. So, if you will bring out juror number 785. Yes. And, sir? He's gone. Let's make sure she brings everything with her. She will, I'm sure. Tony. Good morning. Yes, ma'am. Up here. In your normal spot's fine. If you just remain standing for me. Good morning. You doing okay today? All right. I have, as you know, we've had some discussions with you over the past couple of days concerning indications of conversations with few folks not on the jury concerning the case and expressing some opinion about the case. I have reviewed everything, including statements given by individuals and recorded interviews, and concluded that despite my order to not discuss the case with anyone, that intentionally or unintentionally you've had some discussions with some folks not on the jury, and which is going to require me to remove you from the jury. You have been by all accounts, great juror and smiled consistently and have seemingly been attentive to the case and performed well, and I'm sure that with all the time you've invested in it, you probably hate not to continue, or maybe you're ready to go. I don't know. But I certainly want to thank you for your service. I'm not suggesting that you intentionally did anything wrong, but that in order to preserve the integrity of the process and in fairness to all the parties involved, we're going to replace you with one of the other jurors. Have you brought everything that you have outside of, you left some stuff in there? What do you have in there?
A dozen eggs.
Say it again?
A dozen eggs.
A dozen eggs?
Yeah, one of the other jurors brought in eggs for everybody for the farm.
Okay.
Eggs in my purse and nut water.
All right. Well, you're going to leave the eggs. You want to leave the eggs or take the eggs? You're going to take the eggs. So, Mr. Bailiff, can you retrieve from the jury room her dozen eggs, her purse, and what else? And a bottle of water. If you can get those things from the jury room. As you know, the identity of the jurors are confidential, not known to the public, and the reason you are still where you are is that cameras are not allowed to videotape the jurors, and we have operated by juror numbers throughout the process, and we'll continue to do so, and your identity will be kept confidential as far as the court is concerned, and we trust that in the event you decide you want to speak publicly about this case, that you wait until after the case is over. You're not encouraged at all to do so, but you have a right to speak to anyone you want to if you decide to do so. No, I have not spoken with her today, but no, this is not related to, I know we also had some conversation was brought up concerning your ex-husband, but that's not a part of this consideration at all. This is totally independent of any other conversation that he might have had concerning you. That's not part of the order of the court. So they're going to get your things, and then once you're removed from the jury, you can't go back in the jury room. We'll have to tell them goodbye for you. Okay, all right. Well, thank you very much. Ed, you can go. Thank you. We get a lot of interesting things, but now a dozen eggs. It's certainly kind of interesting. We'll give her a chance to leave or to take her. She's gone? Yes. Okay, very good. Anything else before the jury comes?
Have we picked an alternate?
Oh, right, absolutely. When they come out, we'll need to select an alternate, and the clerk you have the remaining alternates in a box. Any objection to a blind selection of that alternate out of the box?
Nothing from the defense, Your Honor.
Juror number 254.
Juror number 254 will become part of the panel, or the deliberating panel at this point. 254. Yes, sir. Mr. Griffin.
Your Honor, before the jury comes in, early in my closing argument, we have a blow-up of the photos of Maggie and Paul at the crime scene. I'm going to hold it up so that the jury could see, that the audience cannot see, but I'm just notifying Court TV that please don't display this blow-up during the proceedings. Thank you.
Thumbs up, yes.
Oh, sure. I apologize.
All right, everyone, Judy Gatson, along with Greg Adeline and our Nick Neville, we're just going to fill here until the jury actually takes their seat and they start proceedings. The breaking news, Greg, is that juror 785 has been dismissed from the jury. Judge Newman said in order to reserve the integrity of the process, they said some concerns were raised about some conversations that this juror had with someone outside of the jury about this case, expressing some opinions. He did not feel that it was overly egregious or malicious, but again, to preserve the integrity of the process, he said this had to be done.
One thing stood out, Judge Newman describing her as a good juror, somebody who was attentive. And it's interesting, he used the same type of terms that he once used to describe the jury foreman. So the question is, could this have been possibly the jury foreman that just got dismissed? Hard to gauge or understand, but I think one of the most telling things was Dick Harpootlian's objection there, because you wonder, was it a chance to get a slam on Sled on the record, or was this one of his jurors on the panel that he thought might be one of his? And he does not like to see that juror leaving the courtroom on the day that perhaps we might have a verdict.
Right. That was something that really stood out to me, as, we've heard throughout this trial from the defense about what they say was a sloppy investigation, basically singling out Sled several times for missing evidence, for singling out Murdaugh from the start. So Dick Harpootlian used this chance just now in the last few minutes to say, well, the person who can, the agency that conducted the investigation into this juror was SLED, including one of the people who interviewed this juror was a witness in this case.
And listen, Judge Newman, we're standing by, so as soon as they resume the proceedings, we will take you back inside of the courtroom. But Judge Newman made a point of pointing out to the attorneys and to everyone in the courtroom that the court, Judge Newman, did not interact with SLED at all in making this decision. He said that they talked to this juror. They also brought in the person that this juror supposedly had some interaction with. And I'm just going to refer to my notes because it's important to get all of this right. He said discussions over the past couple of days, they got some indications. They got some indications about conversations that this juror had with someone else outside of the case. Judge Newman said whether it was intentional or unintentional. And you know what, Greg? He gave some grace there because he says this has been a long trial, longer than most people expected. And with a jury that's not sequestered, it's impossible to think they're not going to have any interaction at all. But when you cross that line in terms of talking with people outside of the jury and possibly expressing any sort of opinion, again, he said to reserve the integrity of this process, it had to be done. I also want to mention, Greg, Juror 254. Now, we talked earlier when we first went on air today about the makeup, the demographics of this jury, and we talked about the fact that the alternates remaining, Nick, one man and one woman. We don't know yet, as you mentioned. There are some similarities. Is this the jury foreman that has been dismissed? Will a man or a woman replace this juror on the panel, juror number 254, coming into play now? But all of that will have an impact in these critical closing moments of this trial.
That's right. And you heard, obviously, from Dick Harpootlian talking about just how he feels that this process, it seems a little sketchy to him. You want to make sure at this stage of the game, integrity is the key, as you say, because after all, he's called for a mistrial several times. But we want to get into the courtroom as we begin this closing argument from the defense.
It's his turn. Mr. Griffin.
Thank you, Your Honor. Good morning. Wow. We're at the stage of the case that's called closing arguments. I don't know why they call it argument. I'm not here to have an argument with you in any form or fashion. What I'm here to do today, this morning, is to review the evidence with you that you've heard in the courtroom over the last 6 weeks. And in reviewing this evidence, my goal is to address questions that you may have about what you've heard. And the jury system that we have, frankly, is the greatest criminal justice system in the world, because it's the only system, jury system, that a criminal defendant's fate is put in the hands of his or her peers. In this country, we don't leave the decision of guilt or innocence up to the governor, to the attorney general, to the prosecutors, to the presiding judge. You, ladies and gentlemen, make that decision. And as perfect as our jury system is, there's one thing that I wish it provided: an interchange during the course of the trial between us. You're all sitting there and listening to what we say, and we don't know what questions you have and what you want answered. By the same token, we may have questions of you that we can't ask. Here's my opportunity to try to answer the questions that I think you have. There may be some things that I go over that you've already decided, and I'm wasting your time, and if I do that, I apologize. I truly do. But I don't, this case is so important, I don't want to leave anything out that one of you may have a question about. I think I can probably speak for everybody in this courtroom that there's one thing that we on this side have no question about. It's that y'all have been ideal jurors. We've been here 6 weeks, and each of you have come every day on time, and you've been very attentive, and it has not gone unnoticed. And we do appreciate you for your service. We know what a sacrifice it is, being away from your home, your work, your family, your personal obligations. Maybe some of you miss vacations. But you've been here in a 3-week trial, and here we are at the end of 6 weeks. And I want to thank you personally. I want to thank you on behalf of Mr. Harpootlian, Mr. Barber, Ms. Fox, and especially on behalf of Alec Murdaugh. In his opening statement, Mr. Harpootlian explained to you that the law governing your service requires each of you to engage in an unnatural task. In every criminal case, jurors are required to begin the process by presuming the defendant innocent. In this case, you were required, under your solemn oath as we began, to presume Alec Murdaugh innocent of these charges. And frankly, as he explained, that's not natural. When you hear on the news that a crime has occurred and an arrest has been made, you feel a little bit relieved. Thank God they caught him. And frankly, I would not be surprised if some amongst you, when you read in the paper that Alec Murdaugh was charged with the murder of his wife and son, that you thought, oh good, they got him. But those opinions, and each of you, when you filled out your questionnaire, agreed and affirmed that you would leave those at the door of the courthouse and that you would decide this case solely on the evidence. And that's what the law requires. And when we begin, the law also requires you to presume him innocent of these charges. Now, I've been doing this a long, long time, and up until the advent of instant replay in sports, it's been very difficult to explain just how to do that to jurors, how jurors can do this, apply this presumption of innocence. And if you're not as interested in sports, I apologize for this analogy, but the analogy is the instant replay. Whether you're a Clemson fan or Georgia fan, that on a Saturday afternoon, there's a play called on the field, and then it's reviewed. And under the rules, the call on the field stands unless there's visual, incontrovertible evidence unless and until the state proves his guilt to each one of you individually, voting individually, proves his guilt beyond a reasonable doubt, then that presumption of innocence stays with him. You're not being tasked here to give your opinion in this trial. You're being tasked to apply the Constitution, the bedrock principles that protect us all from a government. And those bedrock principles are, first, you get tried by a jury of your peers. Second, that the jury of your peers begin with presuming you innocent. And third, that you will remain innocent until the government, if they can, proves to you individually, in your mind, that the person is guilty beyond a reasonable doubt. Now, the judge will give you jury instructions on what that means, beyond a reasonable doubt. But the definition has been defined that reasonable doubt is doubt that would cause a reasonable person to hesitate when making an important decision in their personal affairs, such as to buy a house, get married, any consequential decision. And you will be making, when you get this case, probably later this afternoon, you'll be making one of the most consequential decisions that you will have ever made in your life, I suspect. I don't know all of your backgrounds, but it will be a very consequential decision. And if the proof that the state has put before you causes you to hesitate, when you go to fill out that vote as you're deliberating in your jury room, each of you will have a vote. And you will have the right to vote guilty or not guilty. And each of you will write it down. And if there's any reasonable cause for you to hesitate to write guilty, then the law requires you to write not guilty. This burden of proof that we have, many of you may have had experience with civil cases. And in civil cases, the burden of proof is much lower and is called by preponderance of the evidence. And you may have seen lawyers or judges or watched on TV as they give a visual image of Lady Justice, who's blind and who's blindfolded so she doesn't There's not bias for one side or the other, and there's scales on Lady Justice. And those scales are the scales of justice. And in a civil case, if one party proves their case by a preponderance of the evidence, meaning ever so slightly tilt those scales in their favor, then they're entitled to the verdict. There's another heightened level of burden of proof in a civil case called by clear and convincing evidence. And the law requires things like to prove fraud or some intentional acts. You have to prove by clear and convincing evidence. And that's an intermediate level of proof. And so it's not just tilt the scales ever so slightly in the favor of the party that prevails, but you have to get sort of 3/4 of the way there. But now proof beyond a reasonable doubt is the highest standard of proof the law recognizes. And it is, you have to tilt the scales all the way to one side in order for the state to meet their burden. Now, a little bit about the verdict. You will have an option of guilty or not guilty. My friend Dick Harpootlian over here he travels a lot. He's been to a lot of countries, and he recently returned from Scotland, where he attended a jury trial in Scotland. And he tells me it's much like this, except the lawyers wear a wig, and I might benefit from something like that. But in Scotland, it runs about the same until it gets time to the verdict in the criminal case. And the jury in Scotland, where we derive our laws from, they are given 3 options. One option is guilty. Second option is not guilty. And the third option is not proven. Not proven. Now here in America, we have combined the verdict of innocent and not proven into one of not guilty. And so when you go to render your verdict, if it's a verdict of not guilty, it's either you concluded that the defendant is innocent of the charges, or that the government has not met their burden of proof, their heavy burden of proof beyond a reasonable doubt. Now, and one of the reasons that defendants are presumed innocent and the government has such a high burden is because in criminal cases, the defendant really doesn't have the ability, doesn't have the resources, doesn't have the lawful authority to execute search warrants, subpoena documents, to prove his or her innocence. And so a defendant cannot secure a crime scene, cannot lift a crime scene for fingerprints, shoe-wear impressions, cannot secure telephones and get electronic data in the course of an investigation. So the defendant is limited on what they can do. In this case, on June 7th, 2021, Alec Murdaugh called 911, and Deputy Green, and then followed by other deputies, rolled up on the scene. And he is standing on his property. His wife and son lie dead in a pool of blood each. He's within yards of him, and he had just put a shotgun down. He had just put a shotgun down. And what would that look like? 90 out of 100 cases when an officer rolls up, it would look like the person who had the shotgun and 2 dead bodies may have done it, probably have done it. Certainly is someone who should be strongly considered. And all the officers in this case told you that. Deputy Rutland said, yeah, Alec Murdaugh was a suspect, but there are a lot of suspects out there. Everybody was a suspect. Fair enough. Agent Owen says, well, we have a circle, investigative circle, and it starts with immediate family members, particularly if they found the deceased, the victims. So he's in the circle by virtue of calling 911. And that's fair enough. But what doesn't strike us as fair is that the next morning, on June the 8th, after the gruesome murders of Maggie and Paul, this is what is issued, a joint press release, Colleton County and SLED, that says, at this time, there's no danger to the public. At this time, there's no danger to the public. You have 2 people have been executed within, y'all are out there, I don't know, is it 100 yards, 200 yards from Moselle Road? They've been slaughtered. And at this time, there's no danger to the public? Does that tell you that on June 8th, law enforcement had decided it had to be Alec Murdaugh? It's a fair question for you to ask yourselves. It's a question that's not been fairly answered in this trial. What we know from June 7th to June 8th, Alec is a suspect and he's in the circle. And from that day forward, he is at the mercy. He is at the mercy of the ability of SLED to exclude him from that circle. They have the ability to do the forensic work, they have the ability to interview witnesses, and they have the ability to gather electronic data. And we believe that we've shown conclusively that SLED failed miserably in investigating this case. And had they done a competent job, that Alec would have been excluded from that circle a year ago, 2 years ago, but he would have been excluded. What did you hear from the witness stand? You heard from Chief Barry McCroy. I didn't know Chief McCroy until I got involved in this case, but his reputation is outstanding, and he's a consummate professional. And he explained that when he got there, he was concerned that cars would be pulling up and there were some tire tracks that were not being protected, and that they could have evidentiary value. And then you heard from Mark Ball, who had a conversation with Sheriff Hill, who's another fine public servant here. And he also agreed, we've got to stop cars from coming in here to preserve these tire impressions. And it was not done. It was not done. Captain Chapman from the Colleton County Sheriff's Office, he testified about seeing other sets of tire tracks. As you came in off Moselle Road, you probably saw where Deputy Green's vehicle had stopped right at the kennels, but then on the other side, where you saw that Alec was parked and pacing on some of these videos, that's where Captain Chapman had talked about seeing tire tracks, and he tried to track them. SLED was coming on, and then it was like a trail to nowhere. It was a trail to nowhere. Deputy Rutland talked about seeing hair in Maggie's hands, you'll recall. You didn't hear anything about the hair in Maggie's hands from that moment forward. Was it tested? Was it sent off for analysis? There was no evidence of what, if anything, happened to the hair in Maggie's hands. Was it as a result of a struggle with her assailant? Was it her own hair? I mean, we don't know the answer to that. We know they failed to take fingerprints from the feed room, and they should have. They failed to properly take footwear impressions from the feed room, or at the apron right outside the feed room. And I think that's I don't think that's uncontradicted. The Agent Worley, who doing the best she can, did not go there to document footwear impressions. Did not do that. You heard from our expert, Mr. Zerchi, what is required. And I believe Dr. Kinsey also agreed it was not done. I know Mr. Palmbach did. And both, now I'll get to the shot angles in a little bit, but both Dr. Kinsey and Mr. Palmbach have the murderer for Paul standing on the concrete. Standing on the concrete. Whether 1 foot's in, 1 foot's out, both feet are in, but there should have been footwear impressions. But we'll never know because it was not preserved. It was not taken. The thing that has baffled us, has completely baffled us, is why did they never take DNA samples off of Maggie's clothes, her dress? Why did they never take DNA samples off Paul's clothes? They never did. They never did. And we asked their investigators, why didn't you? Well, that's somebody else's job. That's somebody else's job. It was never done. But you know whose clothing they took DNA off of extensively? Alec. And you heard Agent Zapata talk about all the different grids on her shirt where DNA was samples were taken. Was Alec assaulted on June the 7th? No, he wasn't assaulted. Was Alec wrestling with the assailant on June the 7th? There's no evidence of that. So why are they taking DNA evidence of Alec's clothing in June of 2021? And there's only one reason. And it goes back to this right here. There was only one reason. Only one reason. Is that they had decided that unless we find somebody else, it's going to be Alec. Unless we find somebody else, it's going to be Alec. And I'll get into more detail about Maggie's phone. And Maggie's phone was not secured properly. Maggie's phone was, well, let me just go right into it. Maggie's phone was found on the side of the road in the morning or early afternoon on June the 8th. Whoever killed her threw that phone on the side of the road, without a doubt. Without a doubt. Alec, from the get-go, has said, you get Maggie's phone, you get my phone, or you get my OnStar data, and you will not see my car traveling down the road with Maggie's phone, because it did not happen. It could not happen. Detective Owen, have you gotten it yet? No, we've not. We sent the black box from on the Chevy to the FBI. It was a new model. Turns out the data's encrypted, and so we haven't got it yet. Well, what about General Motors? I mean, I'll do what I have to do, whatever I can do. And so, well, you know, we're looking into it. We're looking into it. Well, what we learned during this trial is, sure, SLED sent a subpoena via fax machine to somebody in Detroit, I believe, and whoever got it in Detroit, whether there was a number off, I have no idea what the reason was, but we do know the initial response was, we don't have anything. We don't have any OnStar data that you're looking for. There's no indication that SLED followed up with a phone call. There's no indication SLED followed up with a letter. There's no indication SLED did anything other than put it in a file. Put the response in a file. And that was it. That was it, ladies and gentlemen, until somebody watching this trial somewhere contacted somebody at General Motors and said, why don't you guys cooperate with the FBI and SLED on this investigation? And they're like, what are you talking about? So Friday, you know, sometime in the last 6 weeks, lo and behold, here comes all the OnStar data that you got to see. And that would be great. That would be great. But for the fact that when they seized Maggie's phone, it had, they put it in airplane mode. They knew how to put it in airplane mode. Excuse me, I'm losing my voice. Let me get water. I apologize. Now there's pollen, something else. They put it in airplane mode, but what you'll see, I got a photograph, is the location services were still on, meaning still pinging off GPS satellites. And the phones don't hold that much memory. They hold a lot of data, as we have learned, but they don't hold that much memory. And it writes over itself. And for GPS location services, the ping points that we see from Paul's phone on all that data, that would have been on Maggie's phone for the 7th. But for the fact that it wasn't extracted until sometime in like June 16th. I think that's the date, but if I'm wrong, I apologize. But it's around the middle of June. And that ping information that we see on Paul's phone, for Maggie's phone, it goes back to like June the 9th. Well, a lot of good that does. A lot of good that does. We don't have it. We would have had it had they extracted it earlier. And Agent Dove says we didn't have an updated, upgraded software that would read it. Took us a while to get it. I don't know why it took them a while to get it. There's really no explanation about that. But you heard about Faraday bags. Put it in the Faraday bag. So it's not pinging against satellites, not overriding. They didn't do that. And it's lost. Had they done it, I hope we wouldn't be here. I hope, because I know it would say, because we have enough evidence in the record, and we have to go around our elbow to get to our thumb to get there, but there is sufficient evidence in the record that shows Alec Murdaugh was not driving down the road, Moselle Road, with Maggie's phone in the car and tossed it at whatever time. When he went by at 9:08. I don't know what time they think it's tossed, but that would have gotten him out of the circle. I would hope, but probably not, because they've been so focused on him. Now, as I mentioned, Alec asked multiple times. I think the testimony was 5 times. Agent Owen, you know, if you get this data, it will show I wasn't there. And you know, we didn't learn why they didn't get it off Alec's phone until very recently, because you'll remember on June 10th, he gave SLED his phone. Yeah, you can copy it. Please copy it, because it'll show that I wasn't driving. Now, my phone was not with Maggie's phone at any point in time going down the road, and that I did what I said I did. Well, they did extract it, but what we've learned, the extraction was a superficial extraction. Not because Alec requested it, that's just what they did. Said a logical surface extraction. So they didn't go in and pull out any GPS pinging data like you see on Paul's phone. They didn't get it off Alec's. Now, if Alec had not made those requests to Owen, and they are disputing that, it's one thing you can be 100% sure of, is they would have called Detective Owen up here on the witness stand during their rebuttal case to say, no, he lied. He didn't ask that of me. I mean, they got Sheriff Smalls in here to say, I didn't give him permission to put a blue light in his car. They came and challenged whether he had authority from the sheriff or maybe a deputy sheriff to put a blue light in his car. But they didn't contradict anything you said about, I've been asking for this data that would get me out of the circle. And now we know why it took so long to get the stuff from his car. It's because the FBI wouldn't go to General Motors on this event data. The FBI was up there and they bought a Suburban, they're riding it around, and they're reverse engineering all these systems to try to come up with reports. And then they come in here and tell you, well, it's not complete, some is inaccurate, but this is what we got. And during the middle of all that, that's when, lo and behold, we get OnStar. Thankfully, we did. Thankfully, we did. So then we roll into Labor Day weekend of 2021, where Alex, long-time drug problem, his financial issues, misconduct were exposed. And that made him an easy target for SLED. And I hate to say this, but the evidence is crystal clear. From that moment, they started fabricating evidence Against Alec. Well, Mr. Griffin, that's an awful charge. Don't all lawyers accuse law enforcement of fabricating evidence? And I can tell you, this guy right here was a federal prosecutor, was a state prosecutor, and some of my best friends are in law enforcement. And I don't make that claim lightly. Here, what you have heard is they came up with a report that says Alec's t-shirt had high-velocity blood spatter on it. High-velocity blood spatter. What's that? That means you're within feet of a shooting, and they didn't just say any shooting. It said in their report, it says as a result of Paul's murder. High-velocity blood spatter on a shirt as a result of Paul's murder. That was number one. Well, let's stick with number one. Why do I say that it's fabricated? Well, you heard Agent Zapata said we did hemotrace confirmatory blood tests on that shirt. That means there were two types of tests. There's a presumptive test, which is what they use a product called LCV that makes it turn purple where it might be blood. But it turns purple on other agents as well, including bleach, you heard. And you also heard that the shirt came out of the bag wet and it smelled like detergent. Anyway, they spray it, it turns purple in places. So they think, well, that must be blood. Next thing they do at the SLED lab is they do a confirmatory test to see if it's blood. 0 for 74, not blood, not blood. That didn't stop SLED from going out and pursuing with vengeance this report. They didn't give the no blood test result to the guy in Oklahoma, and when it surfaced, they had a problem on their hands, and they were pushing it up until this trial. And you heard the testimony from the stand that they went from Mr. Bloody Shirt leading up to this trial to Mr. Clean during this trial. And they ask him, and they raise issues during the trial with Blanca, where were his clothes? No one's asking about the man's clothes that he had on the Snapchat video back in, at 7 o'clock with his son until November or so, I think is what she said. I mean, the issue of changing clothes, it was late to the dance, because when they went to, as you heard, when they went to the Collin County Grand Jury to get an indictment that you're going to be deliberating on, they told that grand jury they had an expert report that said it was high-velocity blood spatter. And I asked Agent Owen, I said, when you went to the grand jury and when your guy gave you the report, how'd you not know, you chief investigator, how'd you not know that there's this hemotrace test that says it's no blood? Well, I didn't get the email. I say it in somewhat jest, but could the dog eat his email? I mean, how's a lead investigator in the case not get the lab report that says there's no blood on the shirt? Now, ultimately it was produced to us, and we were raising Cain about it and saying, how can you say this on one hand and that on the other hand? And here we are with a Mr. Clean theory. that he washed off after brutally murdering Maggie and Paul. He takes a hose and washes himself off and gets in a golf cart, butt naked, I guess, and drives to the house. So that's the blood spatter fabrication. The other is this blue raincoat with GSR, and do you remember that testimony? Shelley Smith, who worked for Ms. Libby and Mr. Randolph, had told SLED after September, after Alex's problems had been exposed, after she had a conversation with a Allendale police officer following an accident investigation in which she was in an accident, that on the morning, she said in here, as she told you, on Wednesday after Mr. Randolph's funeral, and that turns out to be, I think, June 16th, that Alex shows up at the house at Alameda at like 6:30 in the morning, knocking, trying to get in, and he has a blue tarp. And in this blue tarp, she lets him in. He goes upstairs with this blue tarp. He comes back downstairs. He lays this blue tarp out on Ms. Libby's retirement rocking chair in the living room, and then he leaves. And then she leaves to go to her day job, and when she left, the blue tarp was laying out on Ms. Libby's rocking chair. That was her testimony. And so SLED gets that, gets a search warrant, goes to Alameda, and they seize a blue rain jacket. They seize a blue rain jacket. And when they do, they take that blue rain jacket and they show it to just about every family member. Let me get it right quick. So they can think of, and it's defendant's 87, Doug, if you can pull it up. But they show this blue rain jacket to as many family members as they can get in contact with, and the rain jacket is, and no one recognizes it. No one sees it. No one said Alex ever worn it. No one said Paul's ever worn it. No one said Buster's ever worn it. No one said Maggie's ever worn it. Have not seen this blue rain jacket. Has not seen this blue rain jacket. One more thing about this blue rain jacket. When they did the search at Alameda, John Marvin was there. And John Marvin asked him, did you find anything? And they said, well, we found a blue rain jacket back on the property. And he said, well, my dad drives a buggy around, and maybe it fell off the back of his buggy. Clearly, John Marvin was understanding that it was back on the property, and then they asked him to come look at the blue rain jacket, and he was told it was found in the closet. And he said, that didn't sound right, and they never clarified it. Now here's a picture. I'm not even going to put it up, but 411 is a picture of this closet, and you can see the blue rain jacket that's just sort of folded up and stuffed down here at the bottom right. That's the blue rain jacket. And apparently right before this trial, they showed Shelley Smith this picture and says, does that look like the blue tarp you saw? She goes, well, yeah, sure, it looks like it. They never showed her this. And she said, this, when I'm saying this, is page 87, it's on the screen. She'd never seen this. But they did GSR testing on this, and it says, whew, that's hot. It's hot. A lot of GSR on that. Manufactured evidence, ladies and gentlemen. And then there's this issue of misrepresenting what are the type ammunition found in the shotguns at the residence at Moselle. Paul was murdered with first shot was a buckshot. Went through his chest. He was turned this way, went in here, and then out under his arm, and that was buckshot. The second shot was into the head, either, depending on what expert and what pathologist, it's either this way or this way, but into the head. And that was still a duck shot. I learned that you can't shoot ducks with anything but steel pellets because they don't want lead in the water. So you got to have steel pellets. And then Agent Owen testified, admitted begrudgingly that he had testified to the grand jury that there were 4 weapons found up on the property in the gun room, 12 gauges that were loaded, or I'm not saying 12 gauges, I'm sorry, 4 shotguns that were loaded with buckshot and birdshot. There's 4 other ones. So that matches. Well, guess what? Totally not true. That was totally not true. And he admitted on the stand it was not true. He admitted telling Alec during the interview, and he said, well, I can do trickery. And we're going to see that shortly. But and then I said, are you trying to trick the grand jury? No, I didn't say that. Well, we walked through it, and he did say it. And he didn't remember it, and you'll remember the testimony. And I said, well, I mean, people make mistakes, don't you? Yeah, that was a mistake. And it's okay to make mistakes, right? Yeah. And you can make mistakes about time. Well, that's the most common thing people make mistakes about. It's not all right for Alec Murdaugh, who's in the center of the circle, who's not all right for him to make mistakes about time. It is not all right, according to the same investigator who says it's okay, happens all the time. But here we go, and then Eureka. They finally get into Paul's phone in April of 2022, and they see Alec. Well, they don't see Alec. They see Cash the dog, and they see Paul's feet walking around, and they hear voices in the background. One of them sounds like Alec. And off they go. They go off and get an indictment from the Colleton County Grand Jury, relying upon high-velocity blood spatter, relying upon 4 guns having the same load, and relying upon a rain jacket that's got GSR on it, and Alex lying about being down at the kennels. Now we know, after we've been here 6 weeks, of those 4 things,
Bixby voice privacy contacts have been updated. To continue, review the updated items on your screen.
I'm so sorry. No, that was turned on. I will turn it off. What we know is 3 out of those 4 things that was presented to the Colleton County Grand Jury that you're going to be deliberating on for the indictments that return aren't true. No blood spatter, no GSR rain jacket that's ever been connected to Alex whatsoever, and there's no loaded gun. So we're left with the lie. We are left with the lie. Now, Alex lied about being down at the kennels in Alameda. And why did he lie? And that is certainly a fair question. And that's and frankly, I probably wouldn't be sitting over there right now. He had not lied. But he did lie. And he told you he lied. And he told you why he lied. He said he lied because, I'll tell you, he lied because that's what addicts do. Addicts lie. He lied because he had a closet full of skeletons, that he didn't want any more scrutiny on him, which is the most ironic thing in the world, because depending on which day of the week, their theory is that he slaughtered his wife and son to distract from a impending financial investigation. But he puts himself in the middle of a murder investigation, and he puts himself in the spotlight of a media firestorm.
That's their motive evidence, and we'll get to that. But he lied. He lied because of his drug paranoia kicked in, and he was clearly in the throes of addiction. He lied for all those reasons. But what he didn't lie for is because he was covering up the fact that he killed Maggie and Paul. That is not the reason he did it. Doug, will you play the dog kennel video, please? I'm going to play the dog kennel video. So just please listen to the voice.
Get back. Quick, Cash. Quick. Cash. Hey, you got burgers now. Hey, Mama. This is a chicken. Come here, Cash. Cash. Quick.
4 minutes later, the state would have you to believe that Alec Murdaugh up and blew his son's brains out of his head and murders his wife after having that conversation about Bubba having a chicken or a guinea. 4 minutes later, their case wants you to believe that this is a family down at the dog kennels doing what families do. They're checking on a dog, tail, Bubba's out running around, and they're saying, Bubba, got a chicken. Now, why would Alec not want law enforcement to hear that? I mean, there's nothing on that tape. There's nothing on that tape that indicates there's any strife, any conflict, any anger, any planning, anybody being afraid, anybody running, anybody scurrying. Nothing. It's Maggie, Paul, and Alec down at the kennel. That's it. And their timeline is based on the fact that this automated thing kind of messed me up, but the point I was going to open this up and say, you know, under their theory, if your phone's not moving for some period of time, you're dead right then. I mean, you could be run over in the traffic 2 hours later, but if you're not answering a text 2 minutes after you receive it, you're dead at that point. And that's their case. That is their case on time of death. Is phone stop moving, you're dead. You've heard testimony from a lot of witnesses. I would say practically every witness who took the stand, who actually knew Alec and Maggie and Paul and Buster, testified under oath how much Alec adored Maggie, she was his all. Some people describe Paul as Alec's best friend. His relationship with him was awesome. And I mean, that was unanimous. Unanimous. I want to just play briefly a clip from Blanca testimony about Alec's relationship with Maggie.
You've also, I think in multiple interviews with Sweat and other folks, described, I think the words were, Maggie.
Please continue, Doug.
All. Isn't that what you told us, Slade?
Yes, sir.
What does that mean? Maggie was his all.
He adored her. He loved her. He adored her.
Worshipped her. I mean, just treated her as somebody he adored, correct?
Exactly, yes, sir.
Now, this was her testimony from the witness stand. And then, in every trial, there's you hope you find, some very authentic witness, part of the fabric of America that comes in this courtroom. And we had it in this case, and it's Dale Davis. And I want you to remember what Dale testified about Alex's relationship with his family. Will you play Dale Davis's?
Me? When you use the phrase lovey-dovey about Alec and Maggie, what does that mean?
It means they loved each other.
What, in your presence, you described them as being lovey-dovey, didn't you?
Yes.
And tell the jury what you meant by that.
Oh, every time I always see them, I've never seen that man even raise his voice at his wife or kids. Or his wife. I've never seen him even, none of them argue. But he always, anything she wanted or the boys wanted, he would try to get it.
And what was your observation about the relationship with Paul?
They like to hunt and fish together. I mean, they drink beer together.
Okay.
That was Dale Davis. Which brings us to the question, why? Why would Alec Murdaugh on June 7th execute his son Paul and his wife Maggie, who he adored and loved? Why? The state's theory is that it was a storm a-coming, clouds are arising, and that his financial house of cards is about to collapse, and he's about to be exposed. And because of that, he does what every rational person would do: go kill your wife and son. That is their theory of motive. That is their theory of motive. And it worked too, by the way. Because he killed his wife and son, guess what? Jeannie Seconder quit asking questions for a few weeks. Oh, in the boating case, that won't be worth anything now that his wife and son have been murdered, because he's sympathetic. Have you heard such? One thing Mr. Waters and I agree on is the best thing about jurors is you bring your common sense in here, and you use your common sense, and that's what it's all about. That's what your collective wisdom. And just collectively think, individually think, what kind of sense does that make? Alex, his financial house is a wreck. He's stealing money from clients. He's got to produce a financial statement, maybe, in a hearing coming up. And his dad goes back in the hospital that day. His dad goes back in the hospital that day, and he ultimately dies a few days later. Okay, so I get a call. Jeannie comes in. My dad's going to the hospital. Paul's coming home. That'd be a good time to kill Paul, wouldn't it? That is their theory of the case. And if you don't accept that, beyond a reasonable doubt, ladies and gentlemen, I submit the verdict has to be not guilty. Because there's no reason for him to do it. No reason whatsoever. Now, you've heard a lot of testimony about these financial crimes, misdeeds, and he told you he did it. He told you he did it to support a very expensive drug habit, and none of that's an excuse, but he is an addict, and addiction is real, and addicts lie, addicts cheat, addicts steal to keep getting their drug. The evidence was permitted in this case for you to hear solely to consider, did he murder his wife and son because he had this storm coming, that he was going to be exposed? Is that why he murdered? That's what they say. That's why he murdered. And that's why you're allowed to consider it. Now, Judge Newman in his jury instructions will tell you that's all you can consider it for. You can't consider it by saying, man, I never knew he could do that. So if he could do that, he must be able to do the most heinous crimes in the world. Kill his wife and son, execute him style. I mean, that's a no-no use of that evidence. The only permissible use of the evidence is that sufficient provocation, motive for him to kill his wife and son? Was it sufficient motive, not provocation? And the evidence in the case is that there was no impending financial doom on June 7th. June 7th was a day which frankly was no different than any other day in the frenetic lifestyle of Alec Murdaugh. He had so many balls in the air, and he even forgot his paralegal's name, and I apologize to her. I think Christy. She said he would come in like a Tasmanian devil. I mean, he was frenetic. And they were on to this $792,000 fee in the Ferris case, and they were asking questions at Chris Wilson's office. But the reason they weren't concerned that he was stealing money. They were concerned that he was sheltering money, trying to hide it from being disclosed in the boating litigation, in which he was a defendant. And they didn't want any part of that. And that situation with the with the Ferris fee, as Ms. Seckinger, Jeannie Seckinger said, that was a one-off. That was completely on its own, different type conduct than all the other stuff that you heard about. That was a one-off. And what happened on June 7th? She says, I'm in his office, and he gets a phone call that his dad's put back in the hospital. And she thinks that he told her it was terminal. He may have, I don't know, but his dad is put back in the hospital. He wasn't terminal that day, but the next day he got the terminal diagnosis. Any event, she takes off her CFO hat and puts on her mama bear hat and hugs him, and a friend hat, and their theory is he slaughters Maggie and Paul to buy time from her investigation. That is it. That is their theory. That is their theory. And it's totally fabricated. They've got no evidence of that. There's no evidence that Maggie was on to his financial misdeeds. There's no evidence that she was about to blow the whistle on him. There's no evidence that he had a $20 million life insurance policy on her, and that if he murdered her, that he could get out of financial bind. None of that. None of that. And I asked Ms. Seckinger, how long of a delay did that buy Alec? Well, a month maybe? A month? A month? That's their theory. That's what their case is built upon. And then this motions hearing is, there's a motions hearing scheduled for Thursday. It had previously been scheduled 2 other times. And it was continued at the last minute on the other occasions because 2 of the lawyers had cancer and were receiving treatments. But it wasn't sure it was going to be continued previously. Did he go murder anybody, to get out from under those prior hearings? No. This had nothing to do with it. And, so they brought the plaintiff's lawyer in. He's an excellent lawyer, and he's, like any plaintiff's lawyer. I'm going to clean his clock. I'm going to take everything he's got. That's what they all say. So then we had to bring the defense lawyer in to say that was a negligent parenting case, and it wasn't worth the paper it was written on. I mean, folks, that's what we are in a murder case, and that's what we're having to deal with because that is their theory of motive. But even if the financial day of reckoning was impending. If it was right there. Alec would not have killed the people he loved the most in the world. There's no evidence that he would do that. We do have evidence of what he would do and did do. And if you'll pull up Defendant's Exhibit 125, which is in evidence. On September 2nd, 3rd, 4th, I forget the date. This is the Labor Day weekend. He gets his drug dealer, Curtis Eddie Smith, to shoot him in the head because he couldn't go on, because it was all going to come crashing down, and he had a big life insurance policy. So when Alex is at financial collapse, he doesn't go kill somebody else. He tries to end it himself. This is a natural response. You don't want anybody to do it. But people kill themselves from being exposed. They don't kill their wife they adore, son, the apple of his eye, as some people have said. That's not. That is, I don't have the adjective for that. That is so outlandish. I don't have a word for it. Totally illogical, irrational, and insane. Those are the words I wrote down. For someone to kill their loved ones when their criminal conduct is being exposed. So, you can take that now. Yeah, thank you, Doug. Yesterday we heard a lot from Mr. Waters. And I've been in Mr. Waters' position. As I explained, I was a federal prosecutor for a number of years. I've been a state prosecutor, part-time mostly. And I've done his job. It's a very rewarding job. And I hold him and I hold his office in very high esteem. But there are just sometimes folks just get caught up in a case, they get a desire to win, they get so intoxicated by the attention that's brought on by the case that they start sort of a win-at-all-cost approach. And I'm going to go through some things that Mr. Waters stated to you that just aren't facts and aren't supported by the facts and the evidence that you heard. And before I do that, I want to give you a cautionary statement. We lawyers aren't witnesses. I didn't take an oath to stand up here and talk to you. I have ethical obligations about what I can say and limitations under the rules, but I'm not a witness. I'm here to talk to you about the evidence. And the same applies to Mr. Waters. You decide what the evidence is. You decide. And
further, we're going to take a short break for about 10 minutes. Please do not discuss the case.